In today's video, we are going to take a closer look at what's been happening in the SEC versus Ripple lawsuit, while there's still no news on the judge's ruling on two key pieces of evidence that could define the outcome of the legal battle. While the crypto community keeps waiting for said news, the SEC has presented new motions, in this case, to keep the name of the experts confidential. We are going to talk about those experts, and why the SEC wants to keep as much information as possible confidential. Stay tuned and find out everything that's been going on in the legal case that could impact the whole crypto market. Hello to the XRP news community, welcome to a new video. If this is the first time you see one of our videos, we send a special greeting, and we encourage you to subscribe to the channel and activate the bell notifications, so you do not miss any videos. I want to tell you that this channel gives away 200 XRP. For a chance to participate, all you must do is subscribe, like the video and leave a comment. The winner will be announced on the 15th of July. In addition to this, get 100 extra XRP if you are on our Telegram channel. The link is in the description. On the verge of the judge's decision on the Ripple versus the SEC case evidence, more speculations and motions are being presented, which seems to be the reason why there's no opinion on when this legal battle may come to an end. This week, Ripple slammed SEC's bid to shield experts in the high-profile crypto case. In a filing, Ripple Labs Inc. said the U.S. Securities and Exchange Commission has made an unprecedented move to keep the names of its expert witnesses under wraps in the agency's highly watched case over the cryptocurrency XRP. The San Francisco-based company told U.S. District Judge Annalisa Torres this weekend that the SEC had insisted Ripple's challenges to 3 SEC experts be filed under seal until the judge decides whether to shield the opinion of a 4th expert whom the SEC says has faced threats and harassment. The experts play a key role in the SEC's lawsuit. They alleged Ripple and its current and former chief executives conducted a $1.3 billion unregistered securities offering by selling XRP, which Ripple's founders created in 2012. This case is being followed by attorneys and cryptocurrency holders all over the world, as it could have legal ramifications for other digital assets. Ripple and the executives have denied the allegations, and the company has argued that XRP has traded and been used as a digital currency. The filings presented on Sunday are, according to the defendants, an abuse by the SEC, in order to protect the information in the case in an attempt to prevent criticism of its experts from reaching the public. Their lawyers wrote, the SEC's attempt to shield the identities and opinions of its experts from any public scrutiny is both unprecedented and unsupported by any evidence of need. They asked Torres to let both sides make arguments and then decide whether any information should be shielded. An SEC spokesperson declined to comment on the allegations made by the defendants, but the agency has implied in filings that a 4th expert, Patrick B. Duty, has been the subject of anonymous threatening postings on social media. Duty's role in the case became public when 6 XRP holders, who were granted amicus status in the case, sought to file their own motion challenging his expert report. The SEC has argued in court papers that publicly releasing information about the report could inflame the discourse and result in further harassment and intimidation. So far, Duty has not made any comments on the matter. The SEC had previously hired Duty to analyze the expectations of token purchasers in its case against Telegram. For those who don't know, in October 2019, the SEC filed a complaint against Telegram, alleging that the company had raised capital to finance its business by selling approximately 2.9 billion grams to 171 initial purchasers worldwide. The SEC sought to preliminarily enjoin Telegram from delivering the grams it sold, which the SEC alleged were securities that had been offered and sold in violation of the registration requirements of the federal securities laws. It was on March 2020 that the U.S. District Court for the Southern District of New York issued a preliminary injunction barring the delivery of grams and finding that the SEC had shown a substantial likelihood of proving that Telegram's sales were part of a larger scheme to unlawfully distribute the grams to the secondary public market. As a result, Telegram agreed to pay $18.5 million to settle SEC charges. The agreement included the return of $1.2 billion to investors and the payment of $18.5 million in civil penalties to resolve charges over an unregistered digital token coin offering. At the time, Christina Littman, chief of the SEC Enforcement Division's Cyber Unit, said, "New and innovative businesses are welcome to participate in our capital markets, but they cannot do so in violation of the registration requirements of the federal securities laws." In a statement, Telegram explained that the company had missed a deadline to launch its TON platform due to a court injunction, and for that reason, the firm had to return funds to purchasers either directly or in the form of loans. They said, "We hope the regulatory environment for blockchain technology in the US becomes more favorable for others in the future." Back to Ripple versus the SEC case, the judge asked for token holders' views for being considered in the lawsuit. In October last year, a Manhattan federal judge ruled that a group of individuals who own digital tokens associated with Ripple Labs Inc. can offer their meaningful perspective in the U.S. Securities and Exchange Commission's case accusing the company of violating securities law. U.S. District Judge Annalisa Torres wrote that the 6 holders of XRP, the world's 7th largest cryptocurrency by market value, could offer opinions on certain legal questions in the lawsuit, which alleges the token is an unregistered security. The case has been closely watched by attorneys in the crypto space, as regulators continue to grapple with how to regulate the asset class. The SEC had sued some digital token issuers for selling unlicensed securities, while other assets such as Bitcoin and Ether have avoided the label. The XRP token holders sought to intervene in March, saying they were de facto defendants in the case and wanted to protect their interests. Ripple's founders created XRP in 2012. The SEC sued the San Francisco-based company and its current and former chief executives in December, alleging they have been conducting a $1.3 billion unregistered securities offering since the token's creation. Ripple and the executives have denied the allegations, and the company has argued that XRP has traded and been used as a digital currency. The legal battle does not seem to have an ending date in sight, and according to the experts following the case, the SEC seems to be working extra hard to drag the case in time while at the same time keeping information from the public that could jeopardize the image of the SEC. So we come to the end of the video. If you liked it, we would appreciate it if you subscribe to the channel and give a like. We publish a daily video. You should also share the video with someone that you think can be useful. See you in the next video.